Welcome back, Free Movement. This is your host, Malik Liberty. And in today's episode, we are going to discuss Shapiro versus Thompson. What if moving to a new state penalized you? Not just socially, but legally. What if you had to wait a full year before getting benefits just because you moved? That's the fight behind Shapiro versus Thompson. In this episode, we go into how the Supreme Court transformed movement into a constitutional right and how that decision reshaped how states treat newcomers. You will hear what that means for drivers and everyday Americans. Here's our roadmap for this discussion. 1. We will set the scene, the welfare residency rules in place then. 2. We ask the legal issue. Is discouraging movement a violation of equality? 3. We walk through the courts, holding and reasoning. 4. We dig into the 14th Amendment as the constitutional source. 5. Then we tie it to everyday effects for motorists and residents. 6. Finally, we will wrap and preview how Sanchez versus Roe carries this further. Back in the 1960s, many states placed durational residency rules before they would grant welfare or aid benefits. A person who had just moved in, even if they met all other eligibility requirements, might be denied simply because they hadn't lived in the state a full year. One key example, Shapiro versus Thompson, 394 U.S. 618, 1969. Justia's opinion, Cornell text. You can go to justia.com or law.cornell.edu. In that case, multiple states and D.C. statutes denied aid to families with dependent children. AF's D.C. benefits to individuals who had not been state residents for at least 1 year before applying. The plaintiffs included women and families newly relocated to those jurisdictions who otherwise qualify for support. The state's justification, they claimed the rule helped prevent welfare migration, people moving purely for benefits, and preserved fiscal integrity of welfare programs. The prior lower courts, e.g. Thompson versus Shapiro, 270 F. SU PP 331 D. Connecticut 1967, had held the statutes likely unconstitutional under rational basis review, but the Supreme Court will go further. Key point. This conflict was not just about welfare. It was about movement, fairness, and whether states could penalize new residents. Procedurally, this case arrived at the Supreme Court on appeal from the United States District Courts, which had already viewed the durational residency statutes as constitutionally dubious. The question presented to the High Court was precise. May a state constitutionally discourage migration by denying newly arrived residents basic public assistance during a mandatory waiting period? The Supreme Court answered decisively, no. The court held these durational residencies requirements unconstitutional because they impose a direct penalty on the exercise of a fundamental right, the right to travel between states, and they created an invidious classification that singled out newcomers without sufficient justification. The majority explained that when a law burdens movement, it implicates a fundamental liberty, interest, and trigger strict judicial scrutiny. Under that demanding standard, the state must show a compelling interest and demonstrate that the statute is narrowly tailored to achieve that interest. The court found the state's justifications protecting fiscal integrity, deterring so-called welfare migrations, and easing administrative burdens. Neither compelling enough nor narrowly framed. In the majority's view, these laws were blunt instruments that swept too broadly and punished people simply for exercising their right to relocate. Consequently, the court reversed the lower court's denial of relief and struck down the one-year residency conditions, holding that treating recent arrivals as an inferior class for access to the essential public assistance violates equal protection principles and undermines the constitutional freedoms to travel within the union. Now, pay attention to what they just state. Violates equal protection, okay? That's Amendment 14th, okay? Equal protection and due process clause. You need to read that. A brief critique. The majority's use of strict scrutiny was powerful for protecting mobility and individual liberty, but it also drew criticism for substituting constitutional review for what some view as policy judgments about state welfare administration. In effect, the decision prioritized constitutional protection of movement over state flexibility in fiscal policy. That outcome fortified the right to relocate, but it limited states' ability to design broad residency-based budget rules, forcing them to adopt narrower, more precisely tailored measures if they want to regulate program access. Now here's the legal issue. So what was the legal question before the court? In simple terms, can a state constitutionally impose, period, denying benefits to newcomers in a way that discourages interstate movement? Put differently, those forcing someone to wait a year before qualifying deprive them of equal protection or penalize their decision to move. Because movement is involved, we must ask, is travel itself a constitutionally protected right? And if so, does this statute interfere with it in a permissible manner? The states argue that their interest in fiscal management, preventing abuse, and budget predictability justify the residency rule. They said, we need some filter. We can't immediately grant benefits to every new resident. The plaintiff said, no. You are pushing someone for exercising the right to move. Here's how the Supreme Court resolved it. Holding, the court struck down the one-year residency statute. It held they violated the Equal Protections Clause because they penalized the constitutional right to travel and created an unjust classification. Shapiro versus Thompson, 394 U.S. 618, 1969, Justia.com. Some key points from its reasoning. The court said that denying welfare to recent arrivals creates an invidious discrimination. 394 U.S. at 627. It held that discouraging the migrations of indigenous into a state is constitutionally impermissible. 394 U.S. at 629-631. The court stated, in moving from jurisdiction to jurisdiction, appellees were exercising a constitutional right, and any classification which penalizes the exercise of that right is unconstitutional unless shown to be necessary to promote a compelling governmental interest. 394 U.S. at 634. It applied strict scrutiny to this classification because the statute implicates a fundamental right. The state's justifications, fiscal integrity, administrative convenience, were not sufficiently compelling nor narrowly tailored. The court also rejected the idea that the statute could be justified by contributions and taxes, or that Congress had authorized such restrictions via the Social Security Act, 42 U.S.C. Section 402B. The court concluded that even if Congress had tried to permit it, the state law would still be unconstitutional. 394 U.S. at 638-641. The court also extended the reasoning to the District of Columbia's version, invoking the Fifth Amendment's due process clause in lieu of the 14th. 394 U.S. at 641-642. The bottom line, punishing or discouraging movement by denying benefits is not allowed in our constitutional system. Constitutional bias. Let's tie this decision to the text of the Constitution, especially the 14th Amendment. The Equal Protections Clause 14th states, because the law burdens movement, the court treated it as touching a fundamental right. And when a law classifies based on a fundamental right, strict scrutiny applies. The state must show a compelling interest and that the law is narrowly tailored. Here, the court found that the states asserted the interest, fiscal stability, deterring migration, administrative convenience, did not justify the burden placed on new residents. The classification was too broad and punitive. Also, the court grounded movement in constitutional traditions. It recognized that the right to travel is not spelled out explicitly, but undergirds the Union. For example, earlier courts had struck down laws burdening exit, Crandall versus Nevada, or restricting entry, Edwards, and the court in Shapiro reaffirmed that movement is part of concept of union, Cornell on residency and travel rights. Thus, the 14th Amendment is the best textual book, the best textual hook they use to enforce the concept in modern context. Implication in the motorist impact. Now let's bring this home. How does Shapiro affect drivers, residents, and state licensing laws? First, a state cannot deny someone newly arrived in a state benefits or services just because they are new, unless there is a compelling, narrowly tailored reason. That includes access to public service, publicly driver licenses, possibly driver's licenses, registrations, subsidies, etc. If a state tried to say you must live 12 months before getting a driver's license or charge you more in your first year as a new resident, that will raise serious constitutional red flags under travel doctrines and equal protection. Shapiro also blocks states from trying to deter welfare migrations by policy. You can't constitutionally structure benefits rules so that movement becomes unattractive. The decision ensures that new residents are not treated worse as a class. They must be treated equally in many aspects, unless the state can clearly justify differentiations under strict scrutiny. For everyday motorists, this means states licensing you, imposing registration delays or extra waiting periods must justify that under constitutional constraints. You have cause to challenge such measures legally. To wrap up, Shapiro versus Thompson elevated the right to travel into the heart of American constitutional law. It said, you cannot penalize movement by denying essential state benefits to new residents. That transformed how states legislate residency rules with real teeth. Your homework before next week. I want everybody to, number one, read Shapiro versus Thompson. You need to go to justia.com or law.cornell.edu. At least the syllabus and majority opinion. Pay attention to the strict scrutiny reasonings and rejection of administration justification. Now, I really don't like too much hearing about opinions too much. Opinions is just opinions. I'm all about facts here. No fluff, no fear, just hardcore facts. Okay, but everybody's entitled to their own opinion. I want the facts. Next episode, we will go into Sentence versus Roe, 1999, where the Supreme Court refined the right to travel into 3 clear components. That's where things get really powerful for motorists and residency law. Stay sharp, stay free. I'll catch you next week.